a young man arrested, a prosecutor with secrets, and a courtroom that failed to protect justice. This is the story of Daniel Harper, a 24-year-old pharmacy technician whose ordinary life unraveled overnight. Accused, prosecuted, and imprisoned, even though video evidence existed that could have proved his innocence. The evidence was there all along, but it was hidden. It was February 2014 in Greenville, South Carolina. Daniel Harper was a model citizen, dependable, hardworking, and well-loved. He worked tech night shifts prepping prescriptions, dreamed of becoming a pharmacy manager, and spent weekends fixing bicycles for neighborhood kids. That Thursday began like any other. At 11 p.m., he clocked in for his shift. He filed prescription orders until after midnight, finished them, and headed to his car at 11:40 p.m., just in time for his 12-hour evening shift. As he drove home at 2:15 a.m., his sedan passed under streetlights and bushes rustled. Suddenly, blue and red lights flashed behind him. He pulled over, confusion and exhaustion visible on his face. A sheriff's deputy approached, flashlight in hand. His car matched the description of the getaway vehicle used in a violent armed robbery at a nearby convenience store at 11:45 p.m., just after Daniel had left the pharmacy. The store clerk saw a man fitting that physical profile. Daniel matched the basics: height, build, race. No crime was intended. But he was now under suspicion. Daniel opened his glove compartment and handed over his license, explaining his work schedule and shift times. He was honest, helpful, cooperative. Inside his car, when asked, were empty boxes of medication and his work bag, no weapons or stolen goods. Yet he was not cleared. The deputy insisted he needed confirmation. Daniel knew he had an alibi. Cameras at the pharmacy and security systems had time-stamped his work. They should have backed him up. But the officer said, "We'll check. Go home for now." He thought everything would be okay, until a week later. That week passed slowly. Every notification made his heart pound. At 8:45 a.m. on Monday, police knocked on the door. Daniel froze. Officers were there to arrest him for armed robbery. He was taken back to the station and Mirandized. They told him he fit the description. They had eyewitness ID. They had his prints on the money. All evidence they needed. He had none of that. He wasn't in the store. He never touched money. But to the outside, he was guilty. In court, Assistant State's Attorney Elaine Whitaker painted a picture that was convincing to some. She stood before the judge and jury, calm and assured. Surveillance was clear. Daniel's car seen leaving the store. Cash recovered matched denominations only Daniel had handled. His fingerprints were found on the money. She mentioned no exculpatory evidence in the case, implying nothing existed beyond the crime scene. That was partly true, at least on paper. Daniel's lawyer never saw the videos that showed Daniel clocking out. None of the defense had. The prosecutor controlled that narrative. At trial, Elaine highlighted two main points: fingerprints and eyewitness testimony. No video, no alibi presented. One eyewitness spoke of a young man who looked like Daniel. Another said the car pulled away matching the make and model of his sedan. Elaine delivered in her closing argument, "If it walks like Daniel, talks like Daniel, and fits the description, how can this jury say it isn't him?" The jury deliberated for 3 hours. Daniel's future hung heavy. They returned a verdict: guilty. Daniel received 15 years for armed robbery. Prison was instant. No grace, no parole before significant time, and certainly no chance for his pharmacy career. Life behind bars transformed Daniel. His black tech shirt replaced by prison whites. Dorm lights bright at all hours. 6 men per cell. 6 strangers who watched his every move. He lost his apartment, his fiancée, his community. Yet he found resilience. Daniel refused vocational programs. He spent evenings in the library reading law books and case decisions. He planned appeals. He kept copies in his mind of pages ripped from legal textbooks, on due process, Brady versus Maryland, discovery rules. He fought the despair. He wrote to innocence organizations. He sent postcards to family. He calculated the years: 15 times 365 times 24 times 60 times 60. Enough time to bury a life. But he resolved to be the one to show the world the truth. In 2016, Daniel filed an appeal. His lawyer requested the full evidence binders for review: photographs, lab reports, logs, surveillance footage. The prosecutor's office responded that all evidence was submitted. There's no missing footage. Daniel filed a Freedom of Information Act request, a tool often dismissed as fruitless. A month later, he received a digital folder marked evidence_restricted.zip, but it contained only PDFs, no video files. He chose to pay out of pocket for local tech, who restored DVR footage from pharmacy records dated February 20, 2014. Sure enough, he was working at 11 p.m. No robbery, no getaway. He took this footage to Justice Forward, a national innocence non-profit. They subpoenaed surveillance tape from the convenience store. They knew what they would find, but the prosecutor's office stood firm, demanding chain of custody audits, blessing protocols, and evidence ownership disputes. In late 2017, Justice Forward filed a post-conviction relief motion on Daniel's behalf, citing new affirmative evidence. Pharmacy DVR video, Daniel at work. Theft of the convenience store footage from the prosecutor's internal files. Forensic experts validating the video consistency, parallax, timestamps. Daniel felt hope return, but so did resistance. Prosecutor Elaine Whitaker filed a counter motion. She wanted the footage suppressed. She claimed chain of custody issues with the DVR backups, image degradation that could mislead the jury, and even alleged evidence tampering. She said the evidence's authenticity was questionable at best. She flew to Greenville from Columbia for a meeting with the court's evidence officer. Their appointment unscheduled, behind closed doors. They reviewed the video and, within days, a report emerged. The footage had lightning strikes and could not be officially verified, therefore, it was inadmissible. The judge concurred. That ruling was swift. Daniel remained incarcerated. Suppression success. Elaine's career praised, but a moral failure ignored. Daniel was shattered, hope stripped again. He retreated to cell solitude for days, barely eating. The world screamed he was innocent, and the world remained silent.
In 2018, a local TV station ran a feature, Inmate with a Solid Alibi. They aired the pharmacy video, juxtaposed with Elaine's suppression order. Viewers gasped. Community activists picked up the cause. Social media flared, #free Daniel Harper. Demonstrations outside the courthouse. Students held up signs, justice over expediency. State lawmakers forced an inquiry into Elaine's conduct. A forensics audit discovered that she had knowingly submitted faxed screenshots, not original video files, to justify suppression. Chain of custody and authenticity were compromised. They unearthed internal emails flagged as high importance and to be destroyed after January 2015, which included messages between Elaine and her deputy asserting that the video empathizes want irregularities and must keep it away from defense. By late 2020, the state's Prosecutorial Conduct Review Board convened a hearing on Elaine's actions. Subpoenas, witness testimony, expert reviews all led to damning evidence. Under oath, Elaine admitted to withholding evidence, manipulating formats, and misrepresenting materials to the court. She served 2 years on paid administrative leave before resigning. Disbarment followed for 2 years. She received no jail time. In January 2021, a judge issued an extraordinary writ of innocence in Daniel's favor. After 7 years, he stepped out of prison. Midwinter frost rang clear as he took his first breath of freedom. He was greeted by a small crowd outside Greenville Detention Center. His fiancée, now married to another, but true friends stood by. Cameras flashed. He didn't speak immediately. No words. He just inhaled. He earned a college degree in criminal justice while incarcerated and began advocating for open evidence laws. He spoke at prosecutor conventions, demanding mandatory digital evidence preservation. He knew firsthand that missing frames equaled missing lives. Greenville's legislature passed the Open Evidence Accountability Act in 2022. It required all digital evidence be submitted unaltered. Videos stored in encrypted, multi-agency repositories. Failure to disclose punishable by up to 5 years imprisonment, fines, and disbarment applied to prosecutors and police alike. Daniel co-founded Evidence Now, a non-profit dedicated to defending the wrongly convicted and promoting systemic reform nationwide. He traveled, spoke, networked, all on behalf of those without voice. Elaine Whitaker remains in private practice. Her law license restored 5 years later. Institutional allies accepted her error in judgment. But communities remember. Survivors from other cases saw patterns emerge, evidence withheld, convictions fast-tracked. Daniel's closing line stayed with many: "You don't know the value of evidence until it's gone. And if those who hold it fear its truth, that truth may never see the light." Like, subscribe and share our stories for people to learn and take precautions. Send us a DM if you know any true life story of injustice so that we can share for people to learn. Thanks.